Hey guys, welcome to Probate Matters. I'm Jenny Dinker. I'm our client onboarding manager with Georgia Probate Law Group and Guardian Probate Law Group.
And I'm Erik Broel. I'm the founding attorney and CEO of Georgia Probate Law Group and Guardian Probate Law Group.
So before we get into everything, we have to have a little disclaimer here. I am not an attorney. Erik is an attorney, but any information that you hear here today is just general information. For your specific situation, please contact our office, and we'd love to talk to you about that.
Absolutely.
So we went over will contest a lot last time.
Yeah.
But there's a lot more to cover over it, I feel like.
Yeah.
That's a topic that there's a lot of different layers to. So I want to revisit that with you, if you're okay with that.
Sure.
So can you go over with our listeners what a will contest is, why someone would contest a will, just a little bit of that?
Yeah, so that's a great question. It is a deep topic. There's a lot of parts to it. And in probate, that's a key type of case we see over and over and over. So a will contest, in simple terms, is just where you challenge a will, right? So if we look at the process as a whole, what has to happen? Well, when someone passes away, if there's a will, someone files that will with the court saying, this is the will of the deceased, this is the will that should be enforced or should be carried out. Well, what happens if someone in the family or some interested party thinks that that will is not actually the last will and testament? That's where will contest comes in. That's where you file something and you challenge the will. So why could we do that? There's a number of different reasons. It could be fraud. Fraud is the most common one, and I'm using that term very loosely, but that's what a typical client would say. I think that this is a fraudulent will. It needs to be overturned. And then we have to look at, well, what are the legal reasons why? It could be because of undue influence. It could be because of lack of capacity. It could be true fraud in the legal sense, which is where our deceased person didn't even sign the will. It was someone else that signed their name. That would be more like legal fraud. Mm-hmm. But when we look at will contest, that's the beginning point, is trying to figure out what are the claims or what are the reasons why we want to contest this will. There's another easy one. This is probably the easiest will contest, is we found a newer will, right? And so we found a newer will. We believe our newer will is the actually enforceable one, and your older will is not enforceable.
Mm-hmm. Yeah. And so we hear this a lot. Is there a timeline in which someone has to produce the original will? So, for example, someone may call our office and say, it's been 3 months since my mother's passed away, but they are not giving me the will. They say they have the will, but they won't turn it over. In Georgia, is there a timeline of when they have to turn that will over?
That's a great question. We get that all the time. Not exactly, but there is a rule. There is a rule that says if you're in possession of an original will, you must turn it over to the clerk of the probate court. Now, what's odd about that is it doesn't say you have to give it to the heirs at law or to the beneficiaries of the will. Now, are they entitled to it? Yes, they will get a copy. Mm-hmm. But the way we would go about enforcing that, utilizing that rule, we would, of course, demand a copy of the will from the other person so that we can see it. They might refuse. Mm-hmm. But then we can go and file something in court and require them to deliver the will to the probate court clerk, at which point it's public record. We can get a copy.
You get it anyways at that point. Okay. So we get the will, we look over the will, and we see it, and we say, nope, we want to contest this will. It's not the right will. Are there potential consequences that they need to be aware of if they're going to contest the will? Is there something that they need to be concerned about if they are going to take those steps to actually file that caveat?
Absolutely. Absolutely. Every time you do anything in the legal world or legal arena, there are always consequences. And anybody who tells you there aren't is lying. So there's little consequences and there's big consequences. So obviously, one consequence of filing an objection or a caveat, what we would call a caveat to a will, is you're going to hold up the process. That could be a good consequence. Might be a great consequence for one side and not a great consequence for the other side. Yeah. But it's going to immediately hold up the process, because when someone's filing the will for probate, what they're trying to do is get themselves usually, but it could be someone else, appointed as the executor of the estate to run and manage the estate. And then that executor is supposed to carry out the terms of the will. But the key here is the executor has a lot of power. So if you're concerned this will is fraudulent, or you're concerned this person isn't going to do the right thing, filing some type of an objection can put the brakes on that real fast. Because when you file the objection, it kicks off what we would call the litigation process, or it kicks off a civil dispute. So immediately what happens is the court's not going to rule on that petition. So that stops an executor from getting appointed right there. And then it opens up the next phase of the dispute process in litigation, which is discovery. And discovery is just a fancy legal word that means investigation. So there's an investigation period or discovery period where each side is given powers under the Civil Practice Act to go and find evidence to prove their point and disprove the other side's point. That, again, you asked me about consequences. Well, that's a consequence, right? Because now by filing that objection, I have the power to go get more information than I otherwise would have, because I have additional powers under the Civil Practice Act. But so does the other side.
Yeah.
So they have the power to investigate as well. And the key during that discovery, and I talk about discovery a lot because it is, I can't overstate its importance. A lot of folks don't always understand the purpose of discovery, and that's natural because they're not lawyers. But you know, we all see in legal TV shows that moment in the courtroom where the case is won, right?
Yeah.
Giving the closing argument, or that key cross-examination of a witness.
Yeah.
And that's great. It's great for TV. But in the real world, cases are won and lost in discovery.
Yeah.
That's where you go and you find the evidence that is going to allow you to prove your case or allow you to disprove their case. I'll take either one. Depending on the case, we might be looking for one or the other or both.
Yeah.
And so that's where cases are won or lost. And so that's a key consequence. And then obviously we go through the remainder of the litigation process. There will be motions back and forth. There will eventually be a hearing where you'll get your day in court, and you can be given the opportunity to prove whether that will is a true will or it's not a true will. And then the case goes on from there. But I think the largest consequences from a legal side are that delay that gets caused and that ability to have an investigation. There's some other consequences that are very practical. And that's, you're going to ruffle some feathers,
Yeah.
right? You're going to have some folks that are unhappy with it. And what I would say to someone that's concerned about that is, one thing you absolutely don't want to do in this type of a situation is delay, is wait. If your gut is telling you, based on your interactions with this other party, based upon your history with this other party, whatnot, if your gut is telling you something's off here, because their behavior, they're not sending you the will, they're not giving information, just something happened at the funeral, which unfortunately is very common, don't delay. Because the person that's trying to get away with something, they're already a little bit morally questionable, and they're going to be relying on your good-naturedness in order to continue forward with their plan to get whatever they feel they're entitled to or what they think they should get. And your delay helps them. And we don't want to do that.
Yeah. And another potential consequence, just thinking out loud, would be, I think we talked about this a little bit last time, is the potential kick-out clause, right? Because if they contest and if, God forbid, it doesn't get settled in some way, you have the potential that you may not receive from the estate. So you have to be very careful. From what I've heard from our attorneys, they have to be careful about making sure that there's a case there to move forward, because you don't want to end up with nothing at the end of the day.
You are absolutely right. They're called no contest clauses. The formal name is an in terrorem clause, like in terror of. There's a bunch of Latin in there. But they're commonly called a no contest clause or a kick-out clause.
Yeah.
That's a key analysis that has to be done at the beginning of a case, because with that kind of a clause, it's one of those where you can't unring a bell. The filing of the objection itself either triggers or does not trigger the clause. And so this is one of those areas where having legal representation, having a good lawyer that knows what they're doing on your side is vitally important, because that analysis has to be done at the get-go.
Yeah.
And every one of these clauses is different. You know, we see hundreds of wills a year, and every one of these clauses is written a little bit differently, and they can turn on the nuance, on the exact wording, the precise wording. We've had them where, you know, whether it was enforceable or not enforceable depended on a comma once, the placement of a comma in a sentence, right? And it's that kind of thing that you get into. So, but the key is, if you've got an enforceable in terrorem clause or no contest clause in a will, then when you look at filing an objection, well, we want to do an analysis of, all right, if we do not file the objection and we proceed forward and we just play the game of sit on the sidelines and watch, and let's make sure everything is done to a T correctly, right? We're going to let the other guy get appointed, but we are going to watch and make sure they dot every I and cross every T and do everything to the letter perfectly.
Yeah.
And if not, we're going to go, we're going to file something, we're going to take them to court.
Yeah.
Right? That's a strategy.
Okay.
Well, what does our client get under that strategy if everything happens perfectly? Alternatively, you want to do the analysis of, okay, if we object and we lose, what do we get? Usually that's nothing, right? Because those no contest clauses are usually, if you object and this will stands, then you're done.
Yeah.
And then if we object and we are successful, what does the client get? And then we want to look at, okay, what are the odds? How do we feel about this? Based upon what we know now, how do we feel? And it always is a how do we feel? And it's a conversation with the client, because at the end of the day, remember, I don't get the powers to do a formal investigation until after I've filed an objection.
Yeah.
But I have to make a decision about whether to file that objection when I'm under a no contest clause threat before I get to do the investigation. So now I have to rely on any informal investigations I can do. We have to rely on what the client is telling us, that the client knows about events that occurred beforehand, any kind of informal witnesses we can talk to, any documentary evidence we can look at. We're relying on those things to make that decision.
That makes sense.
And there's other ways in certain circumstances you can splice some hairs and object sometimes to the appointment of a person without actually challenging the will, the piece of paper. That gets very complex.
So a part of it, but not the whole thing.
Yeah, and you're kind of trying to thread the eye of a needle with that, because you're with that kind of a strategy, you're skirting as close to that no contest clause as you can without tripping over it. And so that's a very challenging strategy, but we embark on it, frequently, or not infrequently, I should say.
Yeah.
Because sometimes that's the appropriate strategy for the case.
Exactly. So we hear this also a lot, of that we do this. This is the only area of law that we practice, of course, is probate. So I know every case is different. Every case is specific to those circumstances. But in your opinion, how would you say a lot of the will contests end up? Where do they end up, if you could put an opinion on that?
That's a great question. And I know everybody wants to know this question. It's hard, though.
They do. They do.
I can't give you an answer. And I think it depends upon the type of case. The not weird thing, but just something you have to understand about this area of law is it is so fact intensive. It is so focused on the particular facts of your scenario. What happened in your estate? Let me give you some examples. A deathbed will where our deceased knew they were dying, they were on their deathbed, they were doped up on all kinds of medicines, legal medicines, painkillers and whatnot that a hospital is providing, that's authorized and prescribed by a doctor. And then they try to sign a will. And in scenario A, they leave everything to the live-in nurse, or to a nurse that was taking care of them, that they have no familial relationship with and just started working with them 3 months ago. And in scenario B, and let's say in scenario A, they had a will that they wrote 5 years ago, and they overwrote that will with this new one, leaving everything to the nurse. Scenario B, they had a will 5 years ago, and they just made an update to it, and instead of leaving everything to their prior spouse, they leave it to a new spouse they married 4 years ago.
Yeah.
I mean, those are wildly different scenarios. The way we'd approach those cases is wildly different.
Yeah.
Right? There's a there's an expectation that a spouse, a wife, that's a natural thing to do. I would leave everything to my wife. When she passes away, she'd leave everything to our kids, right? That feels natural.
Yeah.
The nurse that I met 3 months ago while I was delirious on pain meds, and I'm still delirious on pain meds, that's a different scenario. So you handle the case differently, right? So that's just one example. The history of prior wills in the case. Is there, we've had them, and this is kind of interesting, where you'll have 3 or 4 wills in a row, and you're looking back over a 20, 25, 30-year period, and you've got 3 or 4 wills there. It's like, oh, that's interesting, and you can just kind of follow the flow of how the wills changed. Does that make sense? I mean, it doesn't really have as much of a bearing on our current will and whether our current will is invalid or not, but it can. It shows a pattern. It shows a pattern of behavior. You get folks, fortunately or unfortunately, right? I try not to judge, but you get folks where it's like, if you don't do what I want, I'm writing out of the will. And then, grandma writes someone out of the will, a grandchild, and then a few years later, they're back in her good graces and she writes them back in the will. Right? Do we have like one of those patterns going on where this whole thing makes sense and we can make an argument, Judge, look at the pattern of these wills from here to here to here, right? And so I know this grandson is really upset that he was written out, but I mean, he was out, he was in, he was out, he was in. I guess he lost the lottery that he was out of her good graces when she passed away.
Yeah.
We get those sort of situations. I think also there's technical requirements. Technical requirements, that's an interesting one because they are important, the formalities of signing the will in Georgia. And does the will look legit? We have to have the signature of our deceased and we have to have the signature of 2 witnesses that were there at the time it was signed. And they really need to be able to see the signing ceremony go on. If they can't, there's ways to kind of fix that later. But like that's our typical, ideal, perfect scenario is we've got the 2 witnesses. And then you can also have a self-proving affidavit. Now, once there's a challenge involved, that kind of goes out the window. You need the witnesses again. But how do most will contests end up? Each one is unique. We look at the facts in the situation that occurred. We do the investigation that we need to do to build the best case we feel like based upon those facts. And then, cases only end in one of 3 ways. Either a dismissal, which means, and I'm talking about a party, they choose to dismiss. So one party chooses to walk away. Okay. A mediated agreement, which could involve a dismissal, but that's where everybody agrees on a way to settle the case. Normally, nobody's happy with it. If nobody's happy with a mediated agreement, you might have a decent mediated agreement.
Yeah, that makes sense.
And then the third way is you go to trial and you let the court decide. And that could be judge or jury, depending on the county you're in and also depending on whether either party makes a jury demand.
Okay, yeah. You actually answered one of the questions I had for you while you were going over that about will criteria, because we get that a lot too about does it have to have a certain standard, or is there something when you would look at a will where you'd say, I see some red flags here based on that will. Something on it is just sticking out to me. I know we've had issues in the past, not issues, but where there's some eyebrows raised when people have written on their will or crossed things out with handwriting and stuff. So are there other red flags or things that could be questionable sometimes?
Yeah, that's a good one. So I guess I'll talk about the formalities first.
Yeah.
I already mentioned about how you have to have the signature of the deceased plus 2 witnesses and the line of sight rule and that they've got to be a part of it. The other thing that's interesting that I do want to bring up, and this will sound self-serving to my profession, maybe it is, but it's usually better if a lawyer writes a will. You don't have to have a lawyer write a will.
Okay.
But it tends to be better from an evidence standpoint because if there's a will contest and the will was written by a lawyer and the lawyer conducted that signing ceremony, they're just a strong witness. There's just no other way to put that. The court regards their testimony as strong testimony. If that lawyer walks in and on examination, they say, yep, I do 200 wills a year. I do them all the same way. I have a checklist. This client came in. I always ask these questions to make sure that they're lucid, that they know what day it is, who's the president, kind of basic information. And then I do my own personal assessment. If I don't feel good or my paralegal doesn't feel good, either of us can call it off. We felt good in this situation. We went ahead with the ceremony. Here's the completed checklist of, everything we did on this that's been sitting in my file for the past 5. they make a good witness.
Yeah.
There's just no way around it. And we don't even do wills like in our office. We just do the probate. But I'll tell you what, if we're defending a will and it was written by a lawyer, we feel pretty good about it. We go and interview that lawyer, and if their testimony is going to be anything similar to what I just kind of went over, then we're feeling pretty good about defending that will. If we're on the other side and, you know, we're attacking a will and it was written by an attorney, and, you know, obviously we interview that attorney, you know, maybe a informal interview before we get to a full deposition, and it goes that way. We're like, okay, well, we really need to dig deep here and figure out a way around this testimony.
Yeah.
Because it is going to be regarded as stronger testimony.
That makes sense. Yeah, we do hear it sometimes where they'll, on the consultations, I'll ask the question, you know, did an attorney create the will, or how did that go? And they'll say sometimes, no, I printed it offline, and I make a big mark of that for the attorney to talk to them about, because it can make a difference, we've seen.
Yeah.
I mean, not all the time, but it can make a difference. And what a lot of people, it seems like, don't know about those is that what I've seen is that the wills online could be for any state. So it doesn't necessarily mean it was even for Georgia. It could have been for, you know, any state on that. So I like that you mentioned that, though, that it's better if not better, but it helps in the long run if so there's a problem if an attorney wrote it, because they can be called upon to come and testify if necessary. So on the other side of that, if there is an objection that the client wants to file an objection, do they need an attorney to do that, or can they do it on their own? Yeah,
that's another good question. I would say you can absolutely do it on your own. You can absolutely represent yourself. I don't recommend it. I don't recommend it at all, because it's a complicated process. And it doesn't always work in the way that you would logically think it should work. And that frustrates clients to no end, right? We're constantly having to explain that kind of thing to clients. Clients get frustrated about it, but it's one of those where it is what it is. You know, we know how to handle ourselves in this process, and we know how to get you through this process. And so it's a very time-consuming process. And I find, I mean, the direct truth is, when we go up against a party that's pro se, they usually don't do very well.
And when you mean that, you mean they don't have an attorney?
Correct.
Yeah.
Pro se meaning they don't have an attorney. If our team goes up against a pro se party, it typically doesn't go over, they don't do well.
It's not a level playing field.
It's not a level playing field. And the reality is, our team, we have a fantastic team of lawyers. They do this day in and day out. You know, our firm, because we focus and because we only handle probate type situations or estate litigation type situations, you know, whatever you want to call it, our folks are handling at any given time 60 to 100 estates. Now, those are not all litigated. You know, they've got some that are in a non-dispute status, some that are in that kind of in between. We might litigate, we might not litigate, and some that are, you know, we're going full bore in litigation on this. Well, when you're handling that many of the same type of case or the same practice area of case over and over and over, you just learn details, you learn strategies that someone who's doing it for the first time, or even another lawyer that just does it occasionally, they just don't know. They just don't know. And that's really core to us and to me, to be frank. You know, a big part of the reason why our firm exists and why we do what we do is because of a story in my own past of an estate. It was my uncle's estate, and I went to help. This is when I was in college. And the lawyer that was helping her, I found out later, I didn't know at the time, didn't know everything that he needed to know that could have helped her and changed her situation. So when I got there was an estate sale going on, and I get there, and there's people everywhere, all over her yard. I had gone as a kid and played in this yard, right? In and out of her house. You go inside of her house, and there's little price tags, you know, like the little estate sale price tags are on everything. She's being pushed around in a wheelchair in her front yard. I'll never forget the first time I saw her that day. She's being pushed around in a wheelchair, and just, you can imagine, you know, the stress and the strain of watching your entire life essentially be turned upside down after she just lost her husband. And the house was coming up to be sold. Now, why was the house? Why is all this happening? Well, it's one of those situations where She had kids from her first marriage. He had kids from her first marriage. You know, both of their spouses had passed away. They had gotten together. Everybody seemed great until he passed away. Then his kids decided, well, I mean, we want what's ours, of course, right? It's a very common thing you see. We just want what's ours. So her life got turned upside down. Now, fortunately, the family was able to come together and help her buy the house back from the estate. So she got to keep that.
Yeah.
A lot of stuff was lost. A lot of stuff. And I had gone and talked to the attorney that was there because I was like, I've got to do something. I want to help her. And he kind of, I was a college kid. He just kind of brushed me off and was like, well, this is the way it is, kid, you know, kind of thing. So I go on and I go to law school. And I took, you know, you take all the basics classes, and Wills, Trust, and Estates was one of those classes. I really liked that class. And I thought, you know, we can do something about this. I think that was still kind of in the back of my mind. And as I started actually practicing and really digging in to this area of law, I learned about year support. And the state that she was in does not have year support exactly like we have it in Georgia. However, they have something similar.
Oh, wow.
And it could have made a difference in her case if that claim was pressed. Right? Yeah. Because it could have provided more negotiating leverage.
Yeah.
And what if that had been pressed and this whole estate sale situation was completely changed? What if she didn't have little price tags on everything in her house? What if she wasn't stressing out about whether or not she was going to lose her home?
Yeah.
And so when I founded this firm and decided what do we want to do, one of the things that was foremost in my mind is I want us to be fantastic, the best at something. And I probably because of this experience, I always just like probate stuff. I'm weird like that. I enjoyed reading the treatises. I enjoyed my wills, trusts, and estates class. And I said, we're not going to go all over the place and do divorce on Monday and, you know, business law on Tuesday and probate on Wednesday. And we're going to focus. So every one of our lawyers, every one of them in the office, every one of our paralegals, everybody on our team, the non-attorney staff, this is what we do. We focus on helping clients and helping real people that find themselves in these situations so that when they go through an estate situation, they have a team on their side that knows what they're doing, that knows how to navigate these situations and do it successfully and take whatever their facts are, whatever the client comes to us with to make the best we can make out of that situation.
I'm glad you told your story on that because I think I know it's a pivotal point of why we do what we do. It's the main reason. You know, it was an idea that grew from an experience you had personally. And I believe that speaks volumes about what the firm is and why we do what we do. And I've even been told by attorneys from other offices that there's no one that does probate like our firm does. They'll do probate. Yeah. They'll file for letters of testamentary or letters of administration. They'll file to probate a will, but they won't. Some of them won't do litigation at all because it's so complex. And as you went through the discovery period earlier and explaining all of that, you know, in a nutshell, basically, there's so many layers to it. Yeah. But they won't do that. And then even if it's a non-dispute, what we've been told a lot of times is they'll do the filing, but after that, it's kind of like, hey, you're kind of on your own. You're the executor now, kind of figure it out. But there's a lot more to it. And a lot of people don't know that when they get involved in it. And so they believe, they've been told sometimes if they just get a letter of testamentary, letter of administration, which is appointing them over the estate, that they'll be able to do things. But then they don't know all the other things that come about and the liability they could have and all the problems. Yeah. Because if, as you said, if that claim if they could have been pressed, and your aunt could have taken advantage of that or taken that and said, okay, or the attorney said, this is what we need to do, then it may not have been as traumatic for her at the end of the day. And that's what it kind of boiled down to. It could be a less traumatic situation. Yeah. Grief is always going to be there. Loss is awful, but it doesn't have to be traumatic in the same sense. That's what it sounds like. Absolutely. We can't fix the fact that someone died. Yeah. Our clients grieve. Our clients are on the emotional roller coaster. But I love the way you put it.
we can make it less traumatic.
Yeah.
And if somebody's trying to steal something, we can get in there and help the client and stop the bad stuff from happening. And then in a non-dispute situation, we can just make it go smoothly.
Yeah.
I wish we could make it go faster. If I could make everything go faster, all of our clients would be absolutely happy all the time, right? Because that's something that drives everybody nuts, is how slow the legal process moves.
Yes.
But we can, even though we can't make the courts move faster than they want to move, and there are legal delays in the process, what we can do is we can explain to the client. We can really help folks understand why it works the way it works. Even if we all disagree with it, it does. And then we can help it move along at the pace it needs to and make sure it all gets done right.
Exactly. And you'd said that, if someone's stealing from the estate or doing something, that's where, we can come in and hopefully make that a better situation. That brings me to my next question for you. So if someone, let's say, because we hear this often, someone's just passed away, some people seem like they're in overdrive to get in the house, to start taking things. And then while other people are just planning the funeral, you literally have other individuals who are trying to get in and take documents and take items, whatever it may be. What can we do in those situations? I mean, we consider those emergency situations. I know when someone is actively going into the house and taking things, what can you do?
Great question. I know we've had this situation a bunch. There's one case in particular I personally remember, I think I'll never forget. And this was one where legitimately, not even joking, but it sounds funny, the whole family is at the funeral, except one brother. He's at the house with a U-Haul, loading up as much as he can.
Wow.
It makes sense. Where everybody else is.
They're not there. Yeah.
Right.
Oh my gosh.
But yeah, those are emergencies. And so the number one thing I would say you have to do in this type of a situation is act quickly. Act quickly. And the reason for that is, especially when there is personal property, and when I say personal property, I mean things that can move, things like furniture, things like jewelry, things, what you would find in a typical house, all personal property.
Yeah.
Personal property can disappear, and then it becomes super hard to prove it even existed and that it was in the house and that it was taken. And so by acting quickly, we have a better shot of being able to remedy that situation, or even better, stop it when it's occurring. The other scenario we run into is somebody that tries to go to the bank and get money out of a bank account. Usually financial institutions are pretty good about that. If they were a POA or they were on the account, that can definitely change things in terms of their ability to access it. But again, it's something that we can deal with through the estate process. And then real estate, of course, is much harder, much harder to move around successfully without going through the probate process. And in fact, often you will have to go through the probate process to change title to real estate, which is, in my view, a good thing, because it prevents more fraud from occurring in real estate transactions that we would then have to go fix. So, but when it comes to personal property, I would definitely, if it's one of these situations where everything has been taken, or you think things have been taken out of the house, I would start looking at pictures, photos. Thankfully we all have cameras on our phones, and we've got the ability to take video. I would start looking through that and looking at the background of those pictures, right? Last holiday season, last time you were over at the house, so that you can start to identify, yes, these things were here and I can prove they were here. Because one of the most frustrating things in the world, both for us and for clients, but primarily for clients, and I think it's just because we're used to it, is there's what happened and there's what you can prove to a judge happened. And those are two very different things. And so when a client comes and says, I know that this was here, I know it was there, like, we believe you. I believe you.
Yeah.
Judge ain't going to believe me or you. And so we have to go find the evidence and be able to prove that it existed, it was there, and then we've got to show, and then it left, right? It wasn't given away by the deceased prior to their passing, that it was taken by this other party.
Yeah.
And then, there's a couple ways you can go about it. You can either try to get the stuff back if they have it, if they're, if the other party still is in possession of it, or we can try to figure out what it's worth and then apply some kind of damages. So depending on the type of property, what the perpetrator's intent was, you can go one of two ways. Because you get scenarios where they say, no, I have the property and it's mine, and you fight over it. And then you have the other scenario where they say, I don't know what you're talking about.
Yeah.
I don't have anything. Right? It's like, isn't that you on video? Like
with it?
Yeah, with it, loading it into U-Haul.
Yeah.
And so it just depends. And again, I said earlier, they're so fact sensitive. This is where we get into that. How you handle a case depends on how each party is behaving and what the underlying facts are that start the situation.
And we can, depending on the circumstances, there are options. We don't have to get specific in it, but there are some options of things we can file with the court for emergency relief in some of those situations as well, if necessary.
Yeah, absolutely. So in that one, there's one easy one that's a good go-to is we would file for probably temporary letters. That's treated as an emergency petition. You can get someone appointed to have power of the estate, although their power is exceptionally limited and there's a lot of requirements, like with filings and whatnot that you have to make. So it's going to get the job done because we can tell the court, we think this is going on. We need the power to do 1, 2, 3, 4, 5, and, grant this and let us go on our way. And the court is authorized to do that without giving notice to anybody. Now, that doesn't mean the court will. We've got some judges that have decided they will not grant a temporary petition unless notice is given, even though the statute doesn't require it, but that judge requires it. So you get into differences in different judges in different counties, and you just got to kind of know how they're going to operate in that situation, so you can get the job done that you need to get done. But absolutely, we'd file something like that on an emergency basis. And then there's additional petitions we can bring to bear and additional consequences we can bring to bear, such as executor de some tort. That is a claim that would allow us, if we can prove that the act occurred, that we can get a multiple of damages. So what I mean by that is if this item that was taken was worth $1,000, we can ask the court to impose $2,000 worth of damages.
Oh, wow.
1,000 because you took it, and another 1,000 as a punishment because you knew you shouldn't have done that.
Shouldn't have touched it in the first place.
Yeah.
Wow. So with those punishments and consequences, we hear this a lot. Somebody will be on the phone and say, I want them to go to jail. They need to go in jail. Is it a criminal action? Can they go to jail?
Oh, that's a good one. We do get that all the time.
Yeah,
I've heard that from clients. Sometimes I think they should go to jail.
Yeah, that's right. I do too.
But fortunately or unfortunately, depending on which side of this you're on, it's typically considered a civil matter. And so most of the time the police or a solicitor or a district attorney is not really going to look at this as a criminal case. They're going to say, this sounds like a family squabble in probate. That's a civil matter. You need to go see the probate judge to sort that out. They're not going to treat it as like a theft or a crime or something like this. They're just going to more see it as family squabbling. Now, that said, I'm not going to say never. I think in an extreme case, an argument could be made that it was out and out theft. But I will say in the vast majority that I've seen, and I've even talked to some officers, some detectives about it, they just look at it and they say, that sounds like a family squabble, go see the probate judge. And while that can be kind of infuriating to the family at the time, if we take a step back and think about that officer's day-to-day job, this might not be, when you think about other types of crime, murders and
the highest priority.
Yeah. And there is a system in the probate court to deal with this kind of thing. The judge has the authority to decide, you took stuff you weren't supposed to take, and I'm imposing all these damages on you because of it. The judge has the authority. So we have a system that can function to address that.
Yeah.
But I think part of the issue is our own impatience, because seeing somebody get arrested by a cop, that happens right now, right? Waiting for a court to sort it out and a judge to impose that sanctions. I mean, we're talking about a months-long process and getting to the end in a hearing and a trial and all that.
It's a red tape. It's red tape that's necessary, and that's one of the main options, basically, is to go through that process to get those answers. Cool. So we have some Facebook comments and there are questions for you. So I want to go over those. And I encourage everybody, please, if you have any Facebook questions for Erik that you'd like to say, send over about your probate situation, please send it over. I'm going to read this one here. This is from a follower of ours on Facebook that says, shouldn't a will be executed? Shouldn't a will be executed as it's written? Seems like the decedent's will doesn't mean anything now that they've passed away. What would you say to him?
Good question. So the way I'm looking at this question, right, is it's kind of like well, I have the will right here. Why can't we just get started and just do what the will says? And the reason is because all the fraud stuff we talked about earlier. If it were that simple, unfortunately, there'd be a lot more fraud. So the reason why we have a process, and the process is we file the will, the interested parties get notice that a will has been filed, they get an opportunity to object, and then we go through, and then the court, if there's no objection, and the court finds that the will meets the requirement, is going to appoint this person as executor, and now the executor can go forth and carry out the will. It's not that the will isn't effective, it's that there is a process to get to the point where the authority is conferred that allows someone to carry out the wishes of the will. Mm-hmm. And the reason we have that process is a fraud prevention technique, because for every honest person out there that's like, yep, our whole family gets along and this is what it is, you've got another one or two dishonest folks that would really abuse that type of a system. And unfortunately, we see the darker side of that on a daily basis. And so it's a checks and balances thing for me. I think that it's good that it's done that way, because if alternatively, if you were on the other side where someone came up with kind of a sham will, they gave them everything and gave you nothing, then you're going to be happy there's a process for you to go in and challenge that and stop that proceeding, stop anything from happening before there's big losses to the estate.
Mm-hmm. That makes sense. It does. Definitely. So we had another follower who had another comment on here. So he had received his father's will from his sibling and said that there is no way that this is his father's signature. What can he do? He just knows it's not his dad's signature.
Yeah, good question. We get this one very frequently. This would be one of like the fraud, right? Like, let's say it is. Let's say, yep, that's not his dad's signature. All right, well then who signed it, right? Somebody put a signature on there. And so what do? I would say, again, act quickly. You don't want to wait. You don't want to let the estate process go down the road. You don't want to let someone file that will and then you not object, because if you don't object when that will is filed, then you're making the process of remedying the situation much more complicated on yourself. Because when a will's filed and you have an objection period, you have a right to object. Once that period passes, you no longer have that right. You now have to go ask the judge for permission to object. And then if that permission is granted, then you may file your objection. So we don't really want to get into that, right? That adds a lot more risk to the scenario.
Makes it more complicated.
Yeah, makes it more complicated. So, but if we act quick, it's less complicated.
Yeah.
I want to file the objection, because here in your scenario, we've got a good basis, it sounds like, and then that lets me get into discovery. And so now that I'm into discovery, I can go get a whole bunch of samples of our decedent's signature. I'm sure they signed checks from time to time. I'm sure they signed a contract or a deed or a lease or a car purchase or something that I can get my hands on that person signed and we know it was their signature, right? And then we can get a handwriting expert to compare those things. We can look into the circumstances under which the will was signed. We can talk about who was there at the signing ceremony. We can look at who the witnesses are. We can interview them. We can depose them. We can just conduct an investigation. And in this type of a case, that's a normal course of action. Because we have enough to file the objection, but now we've got to use the discovery process, the investigative process, to turn up the evidence that lets us prove that that signature is not actually the signature of the deceased. And a lot of times in this situation, our goal for the client is to get them to the truth.
Yeah.
If the truth is that is not the decedent's signature, that's great. Let's continue forward and let's litigate this case. But if we get to the end of discovery and the truth is, unfortunately, the hand was a little bit more shaky and it didn't look quite like the decedent's signature, but after we've done the investigation, we can't find any evidence showing it wasn't. The client needs to know that.
Yeah.
They don't need to be led on to go further down this path when the truth of the situation is it doesn't look like there's anywhere to go.
Yeah.
And so that's the purpose of that discovery period. And so we'd be looking at if there was mistake or fraud or lack of capacity, undue influence, all those kind of things. to try to vet out this situation and see, is there anything there for us to proceed on?
Okay, that makes sense. So I say this to clients a lot on the phone, that we've been on both sides of the coin, so to speak. So we've been the ones who've said, no, that signature is fraudulent. And then we've been on the other side of it where we say that, no, I'll tell you right now, that is his signature. So on the other side of that coin, if we're defending the signature, are we looking at the same sort of things to prove that?
Yeah, a lot of the same things, right? I mean, because like you said, it is the other side of the coin. So, and then you can, I mentioned before, get our handwriting expert when we were on this side. Well, now this side's going to get their handwriting expert. You're going to have the battle of the handwriting experts about, well, this one doesn't think it's valid and this one does think it's valid. And then we would also be, again, looking into the circumstances of how the will was signed. So from an investigation standpoint, and I'm talking in generalities because, the particular facts of this case would really direct that investigation. But here I've just got, just a basic kind of couple of sentences of facts.
Yeah.
But we would be looking at similar things from each side to try to prove whether the will is valid or not valid.
Yeah. Yeah, that makes sense. It does. We went over a lot today about will contests.
Yeah. I
feel like we covered, still, I think there's more to cover, but we covered a lot.
It's the tip of the iceberg. It's such a deep topic, but I enjoy talking about it. It's a fun topic.
It is. It is. Well, we want to thank you guys for listening to Probate Matters today. Again, I'm Jenny Dinker, and that's Erik Broel. Thank you guys for listening. Please comment, give us some feedback, give us some questions. Please send them in so that Erik can answer some of those for you guys. If you have a specific situation that you need to give us a call about, please contact our office. We'd love to speak with you guys about it, and we'll see you guys next time. Thanks, Erik.
Yeah, thank you. Thank you, Jenny.
Cool.